Hello, this is Professor Weisman's PowerPoint presentation designed to teach the remainder of the criminal justice process course remotely. It can be accessed on Blackboard and on YouTube at Professor Weisman's CJ Courses channel. This is Unit 3, and the presentation will discuss immunity from prosecution and false confessions. In Unit 3, we will be looking at the elimination of the privilege against self-incrimination, which includes immunity from prosecution, the statute of limitations, and waiver. We will also be looking at confessions, which includes a brief history of confessions, the nature of false confessions, types of false confessions, and examples of false confessions. We previously explored the privilege against self-incrimination and the Miranda warning. The privilege, however, does not apply if there is no possibility of incrimination, because one of three things might happen. First, the defendant has been granted immunity. Second, the statute of limitations has run, which means that the defendant cannot be prosecuted for that crime. And third, the privilege does not apply if the defendant has legitimately waived the privilege, so long as the waiver is not a product of coercion. Let's look at immunity. This situation is all too common. Law enforcement wants a person with knowledge about a crime to give testimony at trial so that others can be prosecuted. The witness, however, refuses to testify because the testimony could lead to self-incrimination. The remedy, of course, is to grant the person immunity from prosecution for testimony at trial. Probably the most infamous case is that of Salvatore "Sammy the Bull" Gravano, who testified against his boss, John Gotti, the Teflon Don, in exchange for immunity for committing at least 19 admitted murders. There are two basic types of immunities. The first is called use and derivative use immunity, and the second is known as transactional immunity. Use and derivative use immunity forbids the admission at a subsequent trial of any immunized testimony and any evidence that has been derived from that testimony. It protects the witness against prosecution by prohibiting prosecutors from introducing any part of the actual testimony at trial and/or from any evidence derived from that testimony at any future prosecution of that witness. In other words, use immunity only protects the witness against the government's use of his or her actual testimony in a subsequent prosecution of that witness. Transactional immunity, which is also known as blanket or total immunity, is much broader than use immunity and protects the witness from being prosecuted for any activity mentioned in the immunized testimony, not just the actual testimony itself. So think of immunity this way. At the trial of John Gotti, if Sammy the Bull testified on the witness stand that, quote, "John Gotti told me to shoot William in the head and I did," end quote, then under use immunity, the actual words that Sammy the Bull said, "John Gotti told me to shoot William in the head and I did," could not be used against him in a subsequent prosecution for murder. If, however, there was other evidence of Sammy's complicity in the murder of William independent of his testimony, such as his fingerprints being found on the murder weapon, then he could be prosecuted for William's murder, except that during his trial for William's murder, his statement given at Gotti's trial would not be admissible. Whereas, if Sammy was granted transactional immunity, he couldn't be prosecuted for William's murder at all, regardless if independent evidence was found. Please note that the Supreme Court in Castigar versus the United States held that prosecutors need only grant use and derivative use immunity to compel an unwilling individual to testify. The court stated that this type of immunity is sufficient under the Fifth Amendment's privilege, even though the immunity does not guarantee that the individual will not be prosecuted, as noted in the Sammy the Bull example. Let's see how the statute of limitations may impact the right against self-incrimination. If the relevant statute of limitations has run, there is no possibility of prosecution as a matter of law. Accordingly, the witness can be compelled to testify because he or she cannot be prosecuted for what they say about committing the crime. For example, the statute of limitations for felony burglary is 5 years. So, if a suspect is accused of that crime 7 years later, he cannot refuse to give testimony that the police may want to prosecute others connected to other crimes still within the statute of limitations period. In another example, the Supreme Court held in the United States versus Balsas that no privilege against self-incrimination for a person who refused to answer questions about wartime activities during World War II because statute of limitations had run. Here, it is important to note that the refusal to give testimony not protected by the privilege against self-incrimination can land a person in prison for criminal contempt of court. An individual may expressly waive the protection of the privilege against self-incrimination. Basically, an individual may waive the rights under Miranda to remain silent and or to have an attorney. Before a confession of guilt will be allowed to be admitted into evidence, however, the trial judge must find that it was voluntarily made. That is, whether the confession was the product of an essentially free and unconstrained choice by its maker. The voluntariness of a confession is generally determined by the totality of circumstances in each matter. These can include 1. The defendant's personal characteristics, such as age, education, intelligence, life experience, physical and mental health. 2. The nature of the defendant's detention, which includes considerations of delays in the arraignment process, defendant's access to counsel, the physical conditions of the confinement itself. 3. The manner of interrogation, in which the court will look at the length and number of interrogation sessions, and sometimes the number of interrogators. And 4. Whether the police used force or threats of force, or whether they refused to provide necessary medication. It should be noted that promises that constitute impossible benefits are not acceptable. For example, a promise by an arresting officer not to harass the suspect's family is certainly not allowed. However, deception used by police is generally admissible or allowed, so long as law enforcement does not actually manufacture false evidence to extract a confession. Now, we will explore confessions. In the 1800s, American courts started to recognize that coerced confessions were not trustworthy and should not be used at trial. To illustrate, the Supreme Court in Hopt v. Utah from 1884 stated that, quote, voluntary confession of guilt is among the most effectual proofs in the law, but the presumption upon which weight is given to such evidence, namely, that one who is innocent will not imperil his safety or prejudice his interests by an untrue statement, ceases when the confession appears to have been made either in consequence of inducements of a temporal nature held out by one in authority, or because of a threat or promise by or in the presence of such person which, operating upon the fears or hopes of the accused in reference to the charge, deprives him of that freedom of will or self-control essential to make his confession voluntary within the meaning of the law. End quote. Flowery words for sure, but the concern with coercion, even back then, in one form or another, is apparent. As we learned in the last unit, it was not until the Miranda decision in 1966 that the Supreme Court finally held that a defendant must be warned prior to custodial questioning of his right to remain silent and to have an attorney before custodial interrogation commences or continues in all federal, state, and local prosecutions. Indeed, the Supreme Court has repeatedly stated that once a Mirandized suspect indicates in any matter, at any time prior to or even during questioning, that he or she wishes to remain silent, the interrogation must cease. Further, if the suspect indicates her or his wishes for a lawyer during interrogation, again, questioning must cease until counsel appears. As we learned in Unit 2, police have developed countermeasures to circumvent Miranda, resulting, in part, with suspects falsely confessing to crimes that they did not commit. Research has demonstrated that perhaps at least 25% of confessions are false in those cases in which innocence was later proven. The research also indicates that juveniles, that is, those under 18 years of age, have a much higher rate of false confessions than do adults. Also note that an incredible 71% of eyewitness testimony is the product of misidentification, again in those cases in which innocence was later proven. Imagine the terrible consequences in a case in which a false confession and an eyewitness misidentification are allowed into evidence to be heard by the jury. If you were under interrogation, would you confess to a crime you didn't commit? Juries seem to think that no one who is innocent would ever confess to a serious crime unless they were guilty. Most jurors believe that they themselves would not and could not confess to a crime that they did not commit. Now ask yourself, would you ever confess to a crime that you did not commit? Your response is probably no. I would never confess to a crime that I did not commit. You could be wrong, however, because many people do confess to crimes that they did not commit, as suggested by Dr. Casson, a psychologist and interrogation expert. He said, quote, "There's no one kind of person who can give a false confession. It can happen to anybody." End quote. Dr. Casson notes that false confessions can be categorized generally into three types: voluntary false confessions, compliant false confessions, and internalized false confessions. Let's look at these three. First, voluntary false confessions are those that are given freely, without police prompting. Sometimes they may be given to divert attention from the actual person who committed the crime, such as a parent confessing to save their child from prison. Some people may also falsely confess to committing a famous or infamous crime for the attention that they may receive. Compliant false confessions, the second one, are given to escape a very stressful situation, to avoid punishment, or gain a promised reward. This is typically the main type of confession that results from coercive police interrogations. Prolonged or relentless interrogations can create mental exhaustion for the suspect and may cause the person to confess to a crime that they did not commit in order to escape what feels like a helpless situation, to stop the intimidation, or to gain a reward which might seem trivial in hindsight. Of course, suspects may also falsely confess as a form of plea bargain in order to avoid the risk of a harsher sentence after trial in the event that they are convicted for the crime. The third, internalized false confessions, are those in which the person genuinely believes that they have committed the crime. This usually comes about as a result of highly suggestive interrogation methods carried out on those who are susceptible to such techniques. Let's look at a couple of well-known examples of false confessions. The first is the Central Park Five. The facts are relatively simple. In 1989, 4 African-American male teenagers and 1 Latino male teenager were arrested for the rape and assault of a white female who was jogging in Central Park, located in Manhattan. None of the suspects' DNA matched the DNA collected from the crime scene, which was 2 semen samples that both belonged to one unidentified man. No other substantive physical evidence connected any of the 5 teenagers to the rape. Despite this, they were convicted based partly on police coerced confessions and spent collectively between 6 and 13 plus years in prison. The 5 maintained their innocence throughout the case, the trial, and the prison terms. In 2001, a convicted murderer and serial rapist serving life in prison confessed that he was the Central Park jogger rapist. His DNA was a match, and he provided other confirmatory evidence. Based on this, eventually all the Central Park Five were exonerated. In 2014, they shared a $41 million settlement award. The second case is Chris Ochoa, and you can watch his story in his own words at the link provided on the slide. According to the National Registry of Exonerations, 27% of people in the registry who were accused of homicide gave false confessions, and 81% of people with mental illness or intellectual disabilities did the same when they were accused of homicide. The first link will bring you to the website, and the second link to a dynamic series of graphs. These are all worth viewing.